Anticipatory bail means an application seeking permission from the court to be released if arrested by the police, but only for the particular reason against which permission of anticipatory bail is asked by the accused. According to Section 438 of the CRPC, the High Court and the Court of Sessions are empowered to grant anticipatory bail. That is, a direction to release a person on bail issued even before the person is arrested. Anticipatory bail cannot be claimed as a matter of right. It is essentially a statutory right conferred along after the coming into force of the Constitution. A person apprehending arrest under warrant issued by the magistrate for remanding him to custody under Section 209 can apply for anticipatory bail under Section 438. Anticipatory bail has nothing to do with filing of FIR or charge sheet or issue of warrant of arrest. It is only concerned with arrest. If the accused anticipates that there are chances of him being arrested by the police, he can ask the court regarding issue of anticipatory bail. And if the court is satisfied, the bail will be granted to the applicant. Now let us consider some of the factors which have to be considered by the court while granting anticipatory bail. First, it has been said by the Supreme Court that if the proposed accusation appears to stem not from the motives of furthering the ends of justice, but from some ulterior motive, the object being to injure and humiliate the applicant by having him arrested, a direction for the release of applicant on anticipatory bail in the event of his arrest would generally be made. Second, the Supreme Court has held that a blanket order of anticipatory bail should not generally be passed, and that the court which grants anticipatory bail must take care to specify the offence or offences in respect of which alone the order will be effective. Thirdly, the courts in dealing with the application for anticipatory bail under Section 438 of CRPC is similar to the applications under Section 437 and 439. The consideration governing exercise of discretion for granting anticipatory bail are materially different from those of an application for bail. Next, when the accused is admittedly involved in the offence and when the police want the accused for investigation, application can be rejected. Likewise, when the multi-storied building put up by a building architect is collapsed and the applicant is prima facie guilty of such a serious offence, anticipatory bail cannot be granted. The power of anticipatory bail being of an extraordinary nature should be exercised only in exceptional cases and should be exercised sparingly by the courts. Anticipatory bail cannot be granted to a person apprehending arrest for contravention of Defence of India Rules 1971. Anticipatory bails are mostly refused to the people who are not cooperating with the investigation, or it requires custodial investigation, or in any way they are influencing the evidence of the case. Then awarding of anticipatory bail becomes tough. Moreover, sometimes the heavy section of crimes such as the offence of murder, etc., and the provisions of the Prevention of Corruption Act, etc., also result in the rejection of the application. Now, filing of FIR is not a condition precedent for preferring and disposing an application for anticipatory bail. Coming to the conclusion, the power of anticipatory bail has to be exercised cautiously and only in exceptional cases. That is where the courts strongly feel that the applicant is being framed in the charge and not otherwise. An indirect use of power to grant bail would be an abuse of the judicial process and would shake the confidence of the general public in the judiciary. Thank you.